This morning, it is our very great privilege to be hearing from Ruth Okediji. Professor Okediji is the William L. Prosser Professor of Law and McKnight Endowed Presidential Professor at the University of Minnesota Law School. She teaches contracts, international intellectual property, copyright, trademarks, and IP and development. Her research focuses on issues of innovation policy, economic development, and global knowledge governance in the context of international institutions and public international law. She's authored and co-authored a number of books, including Global Perspectives on Patent Law, The World Blind Union Guide to the Marrakesh Treaty, and Copyright Law in an Age of Limitations and Exceptions. She's also authored an extensive array of articles, commissioned papers, and book chapters, and has been a reviewer and editor for the Journal of World Intellectual Property since 2009. She is an expert in this area, and we're very fortunate that she could join us today. Please join me in welcoming Professor Okediji. You're online, and this is the forward, backward.
All right, wonderful. Thank you, Mackenzie. Good morning. Good morning. You do not have any reason not to have a good morning in this kind of weather in this beautiful campus. So, I'm from Minneapolis and it snowed about 11 days ago, so you should be having a very good morning. I'm delighted to be here, and I know that we are starting a little late, so I'm going to be watching my time. You said about 25 minutes, 30 minutes? Great, perfect. That really means 25 because I will certainly go a little over usually. I wanted to remark for this keynote on a theme that I've been worried about, thinking about, and been involved with for the last several years at the World Intellectual Property Organization. I was so glad to hear Mackenzie in her opening remarks talk about the shift in this particular forum from familiar kinds of openness to really think about openness and its implications in very different models and very different contexts. And this morning I want to share with you the process that has been going on at the WIPO, the World Intellectual Property Organization Intergovernmental Committee on Genetic Resources, Traditional Knowledge, and Traditional Cultural Expressions. This is a field for acronyms if there ever was one, so it's just the WIPO IGC is what I will refer to it as. The WIPO IGC is over a 15-year process. Actually, it began in 2000, so we really are beyond the 15-year mark now. And it's really an effort to address the intersection of intellectual property, which is really conceived of often as the paradigmatic closed system, right? Intellectual property, a system of exclusive rights. Right now, we recognize the dominant theoretical framework for the protection of IP as utilitarian, an incentive given to authors, creators, inventors to invest private resources to develop what would normally be a public good, and as a result, something that they are entitled to exclusively with some limited exceptions for a period of life plus 70 years if it's a copyright, in perpetuity until it reaches a state of genericide of its trademarks, and then of course the patent right for 20 years. And we think of these systems as closed systems. In reality, they're not really closed systems because they do have, in real property terms, easements. There are rights of easements. There are boundary lines. If one thing that we know as first-year law students and as lawyers and really just as citizens is that every property right comes with limits. And in fact, one of the strongest arguments for property rights is that it serves to tell us what our boundaries are. It serves to signal when you are crossing one particular domain into another. So there are actually important factors and important functions that property rights serve. But nonetheless, because of the fairly significant downstream effects of intellectual property rights and because of the nature of the subject matter. And I think this is something that in this conference I want us to really begin to reflect about. We tend to think of property and closedness in negative terms. We tend to think of them as less conducive and less ideal for the public interest and certainly for people in the global south and for development. And of course, there's an entire body of literature. Hernando de Soto and I were at a conference recently discussing this, where he is working with indigenous groups to really begin to formalize property systems as a means of cultivating opportunities for market exchange and for integration into a broader regional economy. But my point is that we tend to think immediately of open versus closed as binary. We tend to think of property versus openness, one being virtuous and one being a vice. And in general terms, I think what we really mean is that with regard to specific types of property and with regard to specific kinds of consequences, open systems appear to be much more consistent with both global justice ideals, distributive justice aspirations, human rights, and of course, also allows a mediation of power relations in a way that property rights often don't facilitate. And so within the WIPO IGC process, you see this tension and this contradiction, frankly, between our general view of openness versus closedness coming to a head, in particular because the subject matter that we're dealing with, what I refer to as new intellectual property assets, I am much in the vein of Shakespeare, that a rose is a rose by any other name. We can call these traditional knowledge, we can call them traditional cultural expressions, indigenous rights, there are all sorts of names that we have for them. Frankly, we can call it the public domain. But each of these forms of social and cultural organization have elements of property. And so the idea that it's either or, that it's simply a binary relationship, is one thing that I want in this keynote to really make sure that we become a bit more skeptical about, and that we begin to think more critically about the consequences of what we describe and think of as openness. As I mentioned, the WIPO IGC was a result of a political bargain. Developed countries were very interested in pursuing a treaty that would facilitate the granting of patents in the administrative context, to limit the number of questions and sorts of the requirements that a patent applicant would have to go through in order to file the patent. And so the Patent Law Treaty was really a facilitating treaty, right? It was a treaty that would undergird and improve the administration of the intellectual property system globally. Most of the time when governments are trying to reduce bottleneck and trying to streamline bureaucracies, we think of this as a good thing. And in that sense, one might think of the Patent Law Treaty as a good thing. But in the context of openness, this is probably problematic, because one of the reasons that we regulate property interests is because that information allows us to plan around other kinds of normative values. We want to know who bought the house next to you. If I was reading on my plane right here in the readers, this month's Reader's Digest, of a young person who said they had a longtime killer living next to them, didn't know, and for 4 or 5 years had this person in their home and fed them and exchanged Christmas gifts, and then one morning the FBI showed up and said, this person has been on the most wanted list for 25 years, you're going to help us bust them, right? And it turns out, because you're a renter, not an owner, your neighbors can't really figure out who you are. And while I'm so glad this young person made friends with someone who had committed many murders years ago, nonetheless, I think most of us would like to know who our neighbors are. We want to love our neighbors, but we also want to know them. And in many ways, systems that eliminate bureaucracy, that streamline processes, that make it easy for property to signal to others, serve a public good. They serve a public welfare function. And so the Patent Law Treaty in and of itself was not a bad treaty for purposes of facilitating the patent law system, but developing countries, particularly South and Latin American countries, said, well, if we're going to have a closed list, if what we want to do is to facilitate the acquisition of property rights, particularly property rights and knowledge, then it's important that we understand where that knowledge comes from. And so the title of my talk, The Genealogy of knowledge, arose from this amazing sort of request, unprecedented in the World Intellectual Property Organization, from the Global South saying, well, we want to know the source of this knowledge. And there was a request then that included in the maximum list of terms that countries could request patent applicants to disclose was the source of that knowledge. If, for example, you were patenting a pharmaceutical product, where did you get, if it was derived from a plant product, where did you get the plant? Did you have permission from the native community from whose land you harvested the plant, right? So this request for disclosure of origin as part of what countries should request within the auspices of the Patent Law Treaty triggered a fierce debate globally and triggered a number of years of impasse in which the conclusion of the Patent Law Treaty was stalled because the Global South, represented in this instance by South and Latin America, simply said, without a requirement, the countries ask patent applicants, where did you get this information, this knowledge that has become a part of your patent, where did you get it from? It would not go through. Well, the outcome for those of you who are intellectual property scholars or practitioners is that there was, in fact, a treaty, and it was a trade-off. The leadership of the World Intellectual Property Organization needed a political kind of solution to this, and so agreed to move the question of the genealogy of knowledge. Where does it come from? Where are these knowledge assets from that you are now enclosing within the intellectual property system? Where are they from? To an entirely different process within WIPO. And that's what gave birth to the WIPO IGC. It is the first what I call property swap in the international intellectual property system. It's also, frankly, the first time, prior to Marrakesh, prior to other treaties that are now on demand, it's the first time that the Global South has actually requested an international treaty, standalone international treaty to address issues of innovation there. So the question then is, what does that give us? Is it a request for more property? Is it really just a swap, a tit for tat? Is it like the law of Moses, an eye for an eye? There is a view of property that is native to indigenous groups and indigenous communities. And as you know, legal realists have often told us that property relations themselves are fundamentally both cultural and political. They're not really legal constructs. Landed property is landed property, but the relationships that we build around property are defined by norms and values that really go beyond the economic. You'll recall, of course, in Great Britain and certainly in much of Europe, where landed property was not only a source of economic wealth, it was a form of social status, where laws of inheritance really determined how power was distributed within a society and within a community. So the idea that property is simply about closed systems, I think is an idea, as I said in my opening remarks, that we need to scrutinize a little more fundamentally. But indigenous views of their property has become the issue within the intellectual property system. And it's become an issue in particular because it's been pitted against what we see as the most open version of intellectual property rights, and that's the public domain. Every time you think about openness in the context of intellectual property, everybody thinks of the public domain. Few people think of fair use or limitations of exceptions or any of the other inbuilt policy levers in the intellectual property system. Almost entirely the first kind of moment in which we think about the virtues of openness is in this context of the public domain. And so my second big point this morning to you is that there is no such thing as the public domain. Competing views of the public domain have been really problematic in the WIPO IGC process. It's a root cause of much of the tension that this process has encountered. And it's a root cause because it has itself become, as I argue, a form of property. The mandate for the IGC really moved into these formal text-based negotiations in which the delineation of rights was necessary. Because this was going to be an international treaty, a treaty that would affect rights across boundaries, the notion of the knowledge assets of indigenous people, say, in Brazil, impeding a claim for a property right or quasi-property right through the patent system in the United States all of a sudden became, as you might appreciate, a really difficult challenge for governments around the world. Now, recall that for many indigenous communities, of course, and particularly many post-colonial states in the global South, there remains a strong embeddedness to the values that undergird communal living, and that includes not only the way of life, but also the way in which innovation is encountered, mediated, shared in relation to cultural values. And so, of course, what has happened is in the intellectual property process at WIPO, in the IGC process, what we have seen is a pitting of the property interests of the global South against the public domain. This notion that the public domain must somehow feature in any international regime that would grant exclusive rights to the innovation that is cultivated in indigenous communities. And so the mandate, as I have there on the screen for you, for the first time in the property realm, intellectual property realm, we have a mandate that addresses the public domain. It is also the first IGC mandate that says you've got to actually discuss the public domain. Now, for those of you who have studied open systems and closed systems and who are fans of the open systems and who are concerned about distributive justice, you can immediately see the tension that this has caused. Because on the one hand, indigenous groups, both under the United Nations Declaration of the Rights of Indigenous People, have a fundamental human right to their property, and that includes both landed property and intangible property. The Convention on Biological Diversity has recognized traditional knowledge and traditional innovation systems as part of the ecosystem in which the preservation of biodiversity must be maintained and in which the rights of indigenous communities must be maintained. And in fact, the CBD does recognize that benefit sharing, the sharing of economic benefits that result from the exploitation of the knowledge of indigenous groups has to be a part of what nations do in the implementation of the CBD. And my good friend and colleague and co-author Margot Bagley has written extensively on the Nagoya Protocol, which today has given teeth to this idea of benefit sharing and disclosure. But we all know that there's no single definition of the public domain, and most approaches to the public domain really begin on an instrumentalist version. Right? This vision of the public domain and this version of the public domain that we are all familiar with is the opposite of property. It is viewed as the land of the free, right? The home of the brave, the place where things grow, and anyone has unfettered access to this domain, not only to experience knowledge assets, but in fact as a source of further creativity. And the public domain in its most popular scholarly dimensions, Jamie Boyle, Jessica Littman, is viewed as something that is critical to the architecture of knowledge today, and critical to the architecture of openness. Now, my friends here and your colleagues here at UC Davis, Anupam and Madhavi, have written in a very influential article that the romance of the public domain has become a fixation, right? Has become an important challenge, and in many ways a barrier to the development and justice aspirations of the global South. Because of course, when you think about the public domain, you are talking about things that are not governed and are not delineated by intellectual property rights. In fact, the only conception we have of the public domain in the context of knowledge goods is the opposite of property. And so I want to suggest as a third major point this morning that our conception of the public domain is as problematic to the global South and to notions of openness as the concept of intellectual property itself. That when we adopt as a starting point that the public domain is the opposite of property, that the public domain is in fact part of the architecture of what makes property possible, we have already started from a premise that strips knowledge and knowledge assets and knowledge rights from the hands of the global South. Demanders within the WIPO process really resist this notion of the public domain. They resist the notion of the public domain because they view it, in effect, as a way of returning or taking back the rights that they have historically held pre-colonialization, that they are now trying to essentially recapture through various international processes. They resist the idea that the public domain is this global commons to which their knowledge assets should automatically be deposited, and they simply don't believe that they should jettison their interests, cultural, spiritual, material, economic interests, in the interests of a global commons or in the interests of a global public domain. And so defending the public domain or denying the public domain has become really a central theme in these international negotiations. I want to suggest to you that the notion of the public domain as an open system is really simply sanitizing what, in fact, the public domain could become in the context of new knowledge assets, particularly in a world in which distributive justice and in a world in which intellectual property assets have become really a fairly significant way in which human rights are mediated. And so it's become this neutral, seemingly neutral, way to express concerns about the effects of new property rights. And really what it does is it destabilizes what I refer to as the status quo in the global knowledge infrastructure. And so whether asserting that granting indigenous groups rights in their innovation is in fact a threat to the public domain and would be inconsistent with openness is something that I view with some skepticism, in part because the open is often viewed as the other. And again, I resist binary kind of categorizations, that the knowledge systems that produce many of the knowledge assets that are at issue and before negotiation at the World Intellectual Property Organization are not always about a control and exclusion. And in many ways, the public domain is actually a dispensable concept in the context of certain knowledge assets when they're held within the environments in which they were created and in which they were meant to be enjoyed. The entitlement claims that indigenous groups that the Global South seek are not just property rights, right? They are a way of regulating the relations between the Global South and private actors in the Global North. The open, in other words, is not always representative of the other, and certainly not when we conceive of the open as something in opposition to intellectual property. And so the demands of these countries in the Global South has been viewed as offensive protection, and I love the way in which, the minute you say offensive, it's just sort of like, okay, they're gonna make us mad, right? But it's been categorized as offensive protection and has been opposed by the United States and by most actors in the Global North. The countries of the Global South have asked not only for traditional economic rights, but also for moral rights. And of course, scholars have jumped into the fray and have said giving these knowledge goods protection would remove what is now in the public domain from that domain. Now, one of the things that we teach our first-year law students, and certainly on the first day of intellectual property class, what we say to our intellectual property students is that, that intellectual property rights are territorially derived. So every country defines the jurisdiction, defines the processes, defines, after the international treaties are taken into account, defines really what rights you get within that territory. There is no global copyright, there is no global trademark, there is no global patent. But there is a global public domain. Somehow a global public domain has emerged. No one knows the origin, and it's all owned, apparently, by the intellectual property system. And so in advocating for the public domain in the context of these rights that are being claimed by indigenous groups in the Global South, developed countries have really said, well, we need to defend the public domain. And how about you just give defensive protection for these knowledge assets? So what are some examples of defensive protection? Well, if you look at what I have, and because of time, I'm not going to go through them in detail, let me just say that all of the examples of defensive protection and the ideas and the proposals that have come forth all defend the status quo, and they all maintain, and in some cases enlarge, patent, copyrights, and trademark rights. So how do we make sure the patent examiners don't give a patent over traditional knowledge that's held by the indigenous groups in the Amazon? Well, let's disclose the knowledge to the world, even though for sacred, cultural, religious reasons, these groups have maintained this knowledge within a particular social cultural order. Well, how do we ensure that there are no conflicts between the First Amendment and some of the uses of symbols and insignia that are so important to First Nations peoples in Canada and, frankly, within the United States? Well, you know, the First Amendment is an absolute protection, and if there's a conflict, the First Amendment always wins. Time and time and time again, defensive protection either reinforces the property rights of others, denies the property rights of the Global South, and does so in the name of openness. And so these defensive measures, as I have said, ultimately serve to prevent the grant of rights that might be, and in fact in many cases are significant to the way and to the economic integration of these groups in the global knowledge economy. And so I want to propose, as I wrap up here, a return to some first principles, and then I will wrap up. Mackenzie, you've not been doing a good job with my time, so I have no idea where I am. I'm just going to blame her. There's a clock right where? Oh, okay. All right. Okay, great. I'm just going to put on my glasses so I can see. Okay. So I want to suggest a couple of things this morning, and I hope that we'll have an opportunity to discuss them in the Q&A session. First, I think that property rights and the public domain are far more malleable, as I have already suggested, than we think of them in the debate between open versus closed systems, and in debate, certainly in the intellectual property system. Let me also suggest that the public domain and openness actually has to have a normative foundation. That when we talk about openness, it's not openness so people can walk into your house at any time they want, at all hours of the night, taking what they want to do whatever they want. Right? That openness itself has property-like characteristics because it must be both regulated and administered for the public good. And in particular, the regulation of openness, the regulation of the public domain, should be regulated within the specific context in which knowledge goods are created, used, and made available. As I point out, the notion of the public here is not a vague reference to the interests of inventors or bioprospectors or any scientist who, in all good meaning, is searching for the next best cure in the world. And ultimately, I think we have to come to grips with the fact that the concepts of openness are going to be both geographically mediated as well as culturally mediated. The public domain and openness will differ and will be construed and will be designed differently because it reflects not only the design principles that are in the intellectual property system, but because also I believe that openness can stand on its own even in the absence of closed systems. Within the particular context of the WIPO system, the whole idea of property versus the public domain really represents too narrow a set of options for stakeholders, and I include those of us sitting in this room as stakeholders, because as I said to an Indigenous group recently, if in fact within your community lies a carefully cultivated plant that has been cultivated for generations and that has a cure for Alzheimer's, I am certain that your community will not withhold that from the rest of the world. We are all stakeholders in the way in which knowledge assets are regulated. The deployment of the public domain has to be reoriented, just like the deployment of openness needs to be reoriented to consider the kinds of interests and ultimately the objectives that we seek to accomplish in the design of knowledge goods. Discourse about the public domain has to include considerations of its role, its function, how it's designed, and ultimately how knowledge assets are transferred from one sovereign group to another. And so to think about this, in my last bullet point, I suggest that a useful first step is to consider the ways in which communities and nation states in the Global South themselves construe the public domain and construe openness, and to begin to embed some of these first principles into our design of open systems. Ultimately, because we are dealing with an intellectual property system that has vested and in which there's a lot of political capital, any international regime dealing with openness, or for that matter, dealing with the public domain, has to deal with the universe of existing IP rights, and ultimately, however, defining publicness or openness only in relation to intellectual property is especially problematic. Those bright line distinctions, as I suggest, may make sense when you have a regime like IP that is already well defined. It makes far less sense when you're talking about a regime that incorporates not only economic interests, but also spiritual and material interests. When you're dealing with a knowledge system, and knowledge systems that have their own sense of public, then the task of the public domain, I suggest, is different. We don't need theoretical precision, but we do need some outside boundaries to help define the role of publicness. At a starting point, we have to, I think, separate or resist the temptation to conflate openness in the public domain in the way it's conceived in the intellectual property realm, and to think about it differently when we begin to incorporate other systems of knowledge. Ultimately, I conclude that there are no easy solutions to dealing with open systems within a global or a common global framework. I suspect that what we will see emerge is a network of openness, where each node in the network looks different, where the boundary lines in that network will allow some use, some access, sometimes a little bit of both, sometimes none. I think we need to recognize that the values of stewardship, collaboration, and sharedness that are so critical to open movements in the United States and elsewhere are fundamentally part of what these communities have grown around. And if you look at early histories of Native Americans' encounter with the British, you will find this sort of perplexity being expressed by chiefs saying, we don't understand how you can own all of this, how you can own the sky. And you will find reflections of property notions as well. There is no single sort of virtuous cycle between open and closed. Between these two domains, we have a range of options, and I think the true measure of being open is recognizing that that range addresses different values and will bring us to different conclusions, but ultimately for the betterment of the human society. Thank you. Oh, perfect.
Hi, thank you so much. I really like the analogy to nodes of openness, and I'm wondering if you can talk about any examples where you think that that context has actually been successful, that the integration of traditional knowledge and traditional conceptions of property has been successfully deployed in those nodes to avoid the binary distinction.
Do you want me to take a couple of questions and answer, or one by one? What's?
That's up to you.
You're the timekeeper, so.
Well, I would answer the question.
Okay, perfect. Thanks. Thank you so much. And in case people are wondering about my glasses, so I don't need glasses to read or see if it's close enough, but once you're right about where you are, I can't see a thing. So, yeah, there's constantly this and that. There are two examples that, of this that I would give, and I think I'm going to start first in the publication realm. So one of the key things that has been a challenge in dealing with these new knowledge assets is that many forms of traditional property, or traditional knowledge in particular, are performed in the context of sacred rituals. Right? Healing ceremonies, for example, in many indigenous communities are also highly secretive and highly sacred. One of the things that has happened with the assistance of Professor Bagley and others in Geneva, there has been a discussion about distinguishing sacred knowledge and giving it very distinct, highly propertized values so that indigenous groups can determine the terms of access and the terms of use within their own cultural environments. One of the reasons that that particular node has worked is because those societies are themselves extremely careful about preserving that knowledge internally, and there are good parallels both in real property and in intellectual property that facilitate and that make sense that sacred traditional knowledge should be guarded and preserved in particular ways. One of the things, however, that has happened is that there needs to be processes that are acceptable to creators of these knowledge goods, whether they're states or local communities, so that access is mediated in accordance with those particular norms. And so we grant the strong property rights in recognition that those groups themselves can mediate the terms of access. And that's a really, I think, important modality, especially where the most sensitive interests are concerned. A second example actually is quite interesting in my view, and it's an opposite example. The Indian government, many of you are familiar that with the cases involving the Indian government and its efforts to challenge patents that have been secured over, say, the neem seed, for example, and efforts to patent turmeric, et cetera. And so that's really a very clear case in which what the government decided and the U.S. Patent and Trademark Office agreed with is that they had to show documentation that, in fact, this was knowledge that has been known to generations of Indians for, time immemorial. And they were able to do that because of the rich literary tradition of the Indian state. Prior to until just recently, this was not the case, because for many groups in the global south, literary traditions are rare. Almost most groups are, in fact, oral traditions. And Professor Bagley, again, in a fairly influential article, wrote about the notion of discrimination and the idea that oral knowledge has not been accorded the same kinds of value as written knowledge. And the U.S. The new U.S. Patent America Invents Act has actually now corrected this so that any kind of prior art, written or oral, can be introduced and can preclude the granting of a patent. And I think that's an important thing. That particular example doesn't tell us what happens to the knowledge, but at least it ensures that it doesn't become recaptured within a system to which it is fundamentally alien. And I think that's a really, really important idea as well. The last example I said I'd give you two, is efforts now going on in the sub-Saharan African region where about 10 countries have come together to design a regional agreement for the protection of traditional knowledge, traditional cultural expressions. And what is interesting to me and most fascinating is the mix of intellectual property and traditional knowledge in very formalistic models. So, for example, most of us here know or heard of Moroccan oil. Moroccan oil that you find in most stores actually has nothing to do with Morocco, of course. They're not in Morocco. They're not the women who cultivate the nut in Morocco see nothing of this. But curiously, the European Union, because of its rich history in agriculture and because of the way in which Europeans are so wedded to the quality of agricultural products, have been the most provocative advancers, demanders of a regime called geographical indications. And within that realm of quasi-property, we now see some room for indigenous products to also find at least a misappropriation-based or registration-based system. And so for those of you who are more real property experts, there's a tremendous amount of work to do, because part of the challenge, again, is that most of these communities are not formalized. And so the integration and the creation of nodes is much more difficult as you go down the value chain. And that is something that I think we, as scholars and as policymakers, really need to think more carefully about. Mackenzie's the moderator.
Yes.
I actually am curious about the mediation process you're talking about, because it comes down to a question of who gets to decide.
Yeah.
So I'm wondering if you could say something about that.
That is a question I hoped you wouldn't ask. So who wants to decide is the question. Who gets to decide? This is a really controversial. And this is a conference in which, we're talking about risks and rewards. Well, this is really risky. My fairly strong position is that where we have exceptional circumstances, Ebola, right, SARS, in moments of epidemics or exceptional circumstances, there has to be a norm that values the global welfare over any nation, state, or indigenous community. In the absence of those extremes, I think that sovereignty over knowledge and knowledge assets has to be monitored within particular sociocultural values. That is a much harder proposition to drill down into law or to drill down into international treaties. And what is happening, however, is that we have a constellation of instruments that are clearly vesting these rights in indigenous peoples. We have CBD, we have Nagoya, we have UN DRIP, and we have this process in WIPO. We have tons of UNESCO treaties that actually do this as well. And so, and the challenge, of course, is that the global south doesn't actually exist in a monolithic form. Neither does it exist as its own particular subcategory. It is embedded in an international framework. And within that international framework, territorial sovereignty is key. So when we think about the global south, one thing I want to push us to do, because I won't be with you all day today, is to think about whether we're thinking about sovereignty in the global south or whether we're thinking about distributive justice. Those are two very different things. Vesting the right in a sovereign state is not the same thing as vesting it in the indigenous communities from where they come.
So first of all, thank you for a great talk. I mean, you are really addressing most of the key issues that the conference was trying to deal with. So if I understand you correctly, you are basically asking us to rethink the public in the public domain, right? So I understand why you think that we have to do that, but so the first question is a kind of pseudo-technical. Mm-hmm. So if you take patent law, right, so you're right, each country has its own law, but there are some basic concepts that cut across. So for instance, take novelty, right? So if in order to get a patent, you have to show that your invention is new vis-a-vis not just the invention in the country, but everything that is known, published, it can be published practice and so on. So there is a, in a sense, the public domain, in my view, is implicitly invoked in the notion of novelty in patent law, because basically everything that can kill your patent, your application, is something that can be anywhere and eventually will go in the public domain. So either it's already in the public domain because it's an old practice, old knowledge, or if it is currently patented, eventually will go. So the really public domain, I think it's already in the key notion of novelty. Mm-hmm. So if the global is already in the law, how do you get it out? Meaning how can you then reframe the public domain in kind of national terms? Yeah. And the second question has to do, so Carol Rose work on public property.
Yes.
Right. So there, I think that she's trying to make an argument, which I like, about the fact that the public is precisely not reducible to place. So the public is not a city. So, the cases she shows, like, there is a beach that the town maintains and claims that should be used only by the residents of the town. Instead, no. The beach is a public property that could be used by anybody. So the fact that the public is defined precisely because it's not connected to a city, a place, a country. So it's the public includes foreigners, strangers.
That's right.
So there is something, in my view, very good about that notion of the public, especially given who's in DC now. So the idea of shrinking the public to the people in a place, it looks kind of strange.
Okay. I'm going to start, Mario, with that, with your second question. You may have to remind me of your first. But I've been spending a lot of time reading Carol's work because there's just some fascinating ideas there. And I was looking for a blackboard, but I forgot that I'm not in the classroom. So every domain has an entry point. So my one criticism of that idea of Carol's is that once you get into the country, it's all ours. We are all the public. But somebody's going to give you a visa, and somebody's going to put you on a plane. That plane has landing rights somewhere. You're going to get in a cab, and you're going to get to the beach, or walk, right? But there is a difference, I think, between an access right and the domain itself. So we all agree that the moon is public, or the sun is public, or the beaches are public, right? Begin to drill down. But getting there and being able to partake of these domains is really critical. So what we're seeing in the literature, something I'm pretty skeptical about, but I completely understand, is this notion of zoning, right? The fact that you can zone even public spaces. When you get on a beach, you're not allowed to just litter the beach. There are things you can do on the beach. There are things you can't do on the beach. So let's forget the access. Let's just look at how we engage with this place of publicness. And I think what I am advocating for is this notion of zoning, this idea that it may belong to all of us in the sense of publicness, but in fact, how we engage it is different. Someone who goes to an indigenous group and says, can I be a part of the ceremony? Can I watch? That's one thing. Someone who just shows up and takes pictures of a sacred ceremony, that's a completely different thing, I think. So the ways in which we engage, the modalities of engagement are probably what I'm more concerned about. And when we define the publicness or openness without a sense of normative value, the people that end up being hurt the most are precisely the ones that we think openness is supposed to benefit. And that strikes me as the exact opposite of what we're trying to do. The second thing that I think is quite interesting is and I make this point in a paper I'm working on now about negotiating the public domain, because actually when the European delegate introduced the idea of the public domain in the WIPO context, I went and I said, you know, this is not a good idea. There has never been a global public domain, never. There's no intellectual property treaty that has ever defined the public. In fact, there are few national laws that define the public domain. The public domain is something that we talk about, we never define, for good reasons. Because something that you don't want in that domain is going to be there, or something that should have been in there is going to be left out. And so we talk about the public domain not as a space, and not even as a place, not even as a kind of definable domain, but we think about the public domain, in my view, the better analogy is like the air. We all breathe it. Some may have challenges. Some places are less pure than others. I don't spend a lot of time in California, but I hear that San Francisco is foggier than other places, or New Delhi. You know, all kinds of differences in the way in which the human environment engages with something that's as free as the air. We don't all enjoy the same quality of that. And I think for indigenous communities to be able to say, here are the terms and conditions in which we engage with this nature of property, is not so detrimental to our concept of publicness that we know today. I frankly would like to re-engineer some of these concepts, because I think that we are doing ourselves a disservice in the modality in which we are engaging them now. The last point that I wanted to make, I thought was really interesting about novelty. Even though it's the same standard, it's actually applied very differently. And it's amazing, when you begin to look at the case law applying novelty, what is novel in one country may not be novel in another. And of course, this is all linked to the administrative capacity of the patent office. What does the patent office, you know, how many resources does it have to track down knowledge that may be out there? So my mentor and former professor, Robert Merges, when I was a student, taught me that the IP system is like Swiss cheese. He says there are holes in it. And some of those holes are deliberate, because we want knowledge to seep through. And I think that to the extent that it's impossible to define novelty or even inventive step or any of these technical things with precision, we're going to see that there are things that are in the public domain of intellectual property, even if they're not in the public domain of other forms of property, because you simply cannot reproduce human judgment at the levels of patent examiners around the world. And it's really interesting, actually, because, for example, the question of morality. You know, there are certain patents that will not issue in certain countries because they violate morals, or what the French would call the ordre public, right? The US has no similar filter. So there are lots of things that may be in the public domain in Europe that would not be in the public domain here, simply because they have this extra filter there. So lots of examples of this, but I think my point is that the public domain is not as open as we think it is. And when we begin to think about redefining, or at least putting contours around it, we've got to think about what's the underlying normative framework that tells us whether this is a commons or whether this is a public domain. And I don't think we've done as great a job as doing that as we probably should.